Hi, my name is Jennifer Storm. I'm the coordinator for advocacy and outreach for Andreassi and Foot. Today we're going to talk about what do you do when the system gets involved in your child's case, or if you are the child, what do you do when law enforcement and prosecutors and other system-based folks start reaching out to you after a disclosure or a discovery of child sexual abuse? First and foremost, it can be very overwhelming, intimidating, scary, and quite traumatizing to have multiple people reaching out to you and wanting to talk with you or your child about the single most traumatizing thing they've ever experienced. Know that you don't have to do anything alone. In every state in the country, you are allowed to have what is called a victim advocate. Every state in the country has victims' rights. Most people don't know that victims have rights. You can always understand and hear about offenders' rights. People can usually actually repeat what an offender's right is because of how frequently we hear of it in the media and on the news. But did you also know that victims have rights? Because they do. You have the right to accompaniment. You have the right to timely information. You have the right to be present at any and all court events. So when you start to have contact with system-based folks, whether it's a law enforcement officer calling you, a prosecutor's office calling you, children and youth calling you, know that your first call can and probably should be to your local rape crisis program or victim service agency. They're going to be able to help navigate all these various processes that you and your family may have to go through. Victim advocates are just what I said. They're navigators. They really know the entire map of the criminal and juvenile justice system, and they can help walk you through. Not only do they walk you through the process, but as they're doing that, they're educating you, they're empowering you, they're kind of preparing and predicting for what is to come ahead. Oftentimes, this really takes a lot of the pressure off the victim and the victim's family. You don't have to be the one researching various statutes. You don't have to research court events. You don't have to dig through websites to figure out when is your next court hearing. Your victim advocate is going to be able to provide all that to you. And usually they're going to provide it to you well in advance. So first and foremost, reach out and get a victim advocate. Make sure that victim advocate is trained and has confidentiality within the system. If they're adjacent to a rape crisis program, 9 times out of 10, they're going to have confidentiality. You might be assigned a victim advocate from the district attorney's office or a local victim service agency, and that is okay too. Always ask, however, if they have confidentiality by law. There's a difference between a confidential victim advocate and a non-confidential victim advocate. And the biggest difference is that it's confidentiality. What you say to that victim advocate who has legal confidentiality cannot and will not be discussed or disclosed with anyone else without your consent and approval. A system-based victim advocate is not necessarily afforded that same right of confidentiality. So anything you say to them, anything your child says to them or discloses can very easily get funneled back to a detective, back to a police officer, back to children and youth, or back to the prosecutor's office. So unless you want that information funneled that way, be very careful when selecting who you choose to talk to and how. In every county that you live in every state, there should be the opportunity to have both confidential victim advocates and non-confidential victim advocates. Best thing to do is always ask in advance. If they don't have a confidential victim advocate to give you, it's just important for you to know that. And so maybe be careful in terms of what you say and how you say things, just so that they don't go back into the system and get used in a way that could be harmful to you or your children. If you don't have access to a confidential victim advocate, always reaching out to a therapist or a counselor for that confidential space for you and your family to process what you're going through is going to be really important. So definitely do that. So as law enforcement's reaching out, as prosecutors are reaching out, as children and youth workers are reaching out, you're going to have to talk a lot. 9 times out of 10, hopefully, your jurisdiction has best practices in place when it comes to child victims of sexual abuse. They essentially say, we want the child to tell the story as infrequently as possible. So typically, if your area is using best practices, they're only going to have the child really tell the whole story from start to finish once, and that story will get recorded. Usually this is done in a child advocacy setting. Sometimes it's done in the prosecutor's office. It can be done in a hospital setting. It can be done at law enforcement or prosecutors' offices. So there could be a variety of places where it's done, but it should usually be recorded. That way that child does not have to continuously relive that trauma and tell their story over and over and over again. The primary reason for that is to ensure that that child is not being further harmed. The secondary, though, is that defense counsel will use multiple stories against victims in court, right? A defense attorney's whole job is to poke holes in the prosecutor's case. So if they have multiple iterations of a child's story and there are even small discrepancies, that's going to get pointed out at trial or during the hearings leading up to trial and could really hurt the prosecutor's case. So you really want to capture that child's story once, get it recorded, and then make sure they have the supportive services around them when that happens. If your county's not using best practices, you can always recommend, can we record this? Can my child only have to say this once or as infrequently as possible? Can you record it? Can you videotape it so that when others need to hear my child's story, they can refer to that? That way my child is not having to constantly repeat themselves. Always know that you can self-advocate. You can tell the system what you want. They may not always listen. That's where your victim advocate can also be a huge help. Sometimes funneling information from your victim advocate up to the detective or up to the prosecutor is a great way to get information kind of delivered and relayed. Oftentimes, your victim advocate is also going to get a quicker call back from that police officer. They're going to get a quicker call back from that prosecutor, or they might be in the court system and be able to see that prosecutor or see that detective in a much more casual way than you as the victim would be able to do. So if you give the information to the victim advocate to give to the entity you want to have it, it'll oftentimes get there quicker. And adversely, if you have questions, those answers can get to you quicker too. So make good use of your victim advocate. That's their whole purpose, is to be there for you, to facilitate your rights, and to make sure that your time in the justice process is as least traumatic as possible. Know that it's going to be hard. There are going to be a lot of delays. There are always often continuances and delays in any court proceeding, from traffic court all the way up to homicide cases. In some cases, there are frequently more continuances than most. We see that in child sexual assault cases. We see it in homicide cases. So it's not uncommon for multiple continuances to be requested and for those to be granted. Now, a lot of times that's really purposeful, right? It's so that the prosecution can prepare for the case. They can get all the evidence that they need. Sometimes they might have to send away for transcripts or send away for, telephone records or any other pieces of evidence that require them to go to a third party. That stuff takes time. The defense is doing the same thing. They have a job to defend the person in this case. So just know that delays are normal, continuances are common, and to kind of get used to that, this won't be readily kind of absolved in a timely manner. Usually it takes a lot of time, so be prepared for that. And again, know that your victim advocate is there to help your understanding of that. And in some jurisdictions, victims have the right to a speedy resolution in their case, and you can always assert that right. Now, different jurisdictions enforce victims' rights, whereas other jurisdictions are necessarily not that great at enforcing victims' rights. So it's important to know what the law is in your state, and to learn that you can go to the National Crime Victim Law Institute's website, or ncvli.org, and they'll take you through state by state what your victims' rights are. It's really important to know your rights because it happens all too often where victims' rights are completely infringed upon. And when you're a child and you're a parent or a caregiver advocating on behalf of that child, we want you as empowered with those rights as possible so that you can facilitate the smoothest possible and interaction with the justice system as possible. It is scary, it is intimidating. It doesn't have to be as scary and as intimidating as it often is for survivors. This is why we want you to be informed, be empowered, and know what your rights are. Thank you.